Hello, legal professionals. Today, let's delve into a crucial aspect of tenant rights, the importance of Section 56 in eviction cases under the Maharashtra Rent Control Act, 1999. Imagine this scenario. A judge issues an eviction decree but forgets to include Section 56. Sounds like a minor oversight, right? Wrong. This can be a significant procedural and legal flaw. So, what makes Section 56 so vital? Let's break it down. Section 56 mandates that landlords must provide compensation or alternate accommodation to tenants, known as pagri tenants, in eviction cases. It's not optional, it's statutory. When this provision is omitted from an eviction decree, it essentially makes the decree incomplete and non-compliant with the law. Here's why this is a big deal. First, a decree without Section 56 can be considered illegal or infirm. It violates the tenant's statutory rights and can be challenged for being unjust. This omission could lead to the decree being recalled, amended, or even nullified. Now let's talk remedies. What can a tenant do if Section 56 is missing from their eviction decree? First, they can file for a recall or review of the decree under Order 47 Rule 1 of the Civil Procedure Code. The grounds. The judge overlooked a mandatory provision, which is an error apparent on the face of the record. Second, the tenant can appeal the decree in a higher court. They can argue that the eviction decree is incomplete and goes against tenant protection laws. Third, if the decree is final, tenants can invoke writ jurisdiction under Article 226 or 227 of the Constitution of India. They can ask the High Court to quash the decree or direct the landlord to comply with Section 56. Fourth, if the eviction has already been executed, tenants can file a separate suit for compensation under Section 56(I). The law guarantees this compensation, regardless of whether the court initially included it. Supporting these remedies, there are solid judicial precedents. Courts have consistently ruled that landlords must provide compensation under Section 56. This highlights the landlord's obligation and reinforces the unclean hands doctrine, where a landlord cannot benefit from an eviction if they ignored the compensation requirement. In conclusion, an eviction decree that omits Section 56 is legally flawed. Tenants have the right to challenge it, seek its recall, or demand their compensation through appeals or separate legal proceedings. Consulting with a lawyer specializing in tenant rights can be immensely helpful in drafting these applications or petitions effectively. Thanks for watching. Stay informed and ensure justice is served.